do that. Well, good morning and welcome, and thank you for coming to the committee this morning, and thank you for changing the time. As you know, we are consumed with the EU withdrawal bill in this House, and that's why we had to change the timings. It's actually where we'd like to start the questioning as well, if we may. And we know that a great deal has been said about the role of the courts and how Brexit may impact, and we've had discussions on this in the past. There is the question of legal certainty. There is the need for clarity for people to know where they are, and we would welcome any views you want to express on that. But can we just ask at the start what discussions you've actually had with the government about the concerns that you have in this area, and whether in fact the government is keeping in touch with you and your colleagues on the Supreme Court to try to express the concerns that have already been spoken of?
Well, there are two things. One is, of course, the Ministry of Justice has asked us as a court what we foresee, how we foresee Brexit affecting the business of the courts. And we have foreseen 5 different sorts of case that might come before the courts. There might be further challenges to the constitutional process, similar to the Miller one, but a different one, no doubt. There might be judicial review challenges to the use of the Henry VIII powers. There might be challenges to or from the devolved legislatures and governments relating to the location of powers. That's looking more and more likely as we speak. Those are all relatively short-term things that are likely to, if they crop up at all, are likely to crop up in the relatively near future. But then there are likely to be, over the long term, challenges to the interpretation of the EU-derived law, which remains part of the UK law, including claims that we should depart from existing jurisprudence, and of course claims that we should make our own jurisprudence in relation to matters that come up later where there is none at the moment. And that could be a very large number of cases, we don't know, and it would go on indefinitely. And then there could be issues arising from Brexit which have nothing to do with EU law, but arise as a result of Brexit. So we've got 5 different categories of case. Obviously, the concern that my predecessor and I and others have voiced is that in relation to post-Brexit Luxembourg jurisprudence, what are we supposed to do with it? And this is clause 6.2, about which you all know everything. The current draft we find very unhelpful, because in the first place it says we don't have to take account of Luxembourg jurisprudence, and then it says we may do so if we think it appropriate. And we don't think appropriate is the right sort of word to address to judges. We don't do things because they're appropriate, we look at things because they're relevant and helpful. But we don't want to be put in the position of appearing to make a political decision about what is and is not appropriate. So that's the concern that's been voiced. And I should mention, as I think Lord Neuberger mentioned, that there is a small group of senior members of the judiciary who are working on technical issues with both the Ministry of Justice and the Department for Exiting the EU to raise concerns of this nature. And Lord Mance is part of that group, so he may want to add something to what I've said.
Yes, we've had a series of what I think have been, and I hope have been, productive and useful meetings. Obviously, we're not concerned with approving drafts or drafting, but what we are concerned is, as Lady Helder said, technical issues, problem areas which we see arising out of existing proposals. And one of the focuses has been on clause 6.2, which and I think we welcome the attention which is being given to that, because although it's probably only an ultimate backstop, it's quite an important one. I say it's an ultimate backstop because there are a number of interim possibilities which will certainly operate. For example, ECJ decisions will bind in respect of references made prior to the end of the transition period. Similarly, it now appears, reading the draft that came out a couple of days ago, references may be made after the end of the transition period in respect of prior facts occurring before the end of the transition period. In either of those two cases, the ECJ decision will bind, so there's no problem, although there is an interesting question as to what the force of the word may is. If you're not obliged to make a reference, can you decline because you're confident of the answer, because you don't like the answer, which you think you might get? I suspect that isn't the intention. I think some guidance might be helpful in that sort of area. Presumably that sort of decision on prior references and prior facts would only bind inter partes because of the general provisions of Clause 6, which say that as regards other people who are not parties to the particular litigation, ECJ decisions are not as such binding. But that's an interesting question. All these sort of problems have been, I think, usefully raised in a series of meetings which are continuing. We've got another area, which is, of course, citizens' rights, where we know that the ECJ will have jurisdiction for a substantial period of years, and that won't create a problem. But then Clause 6.2, one comes back to as the backup. If there's nothing else there, we know that EU law will be retained as far as possible, as at the end of the transition period now. And the question is, what is the force of Clause 6.2? And I think that needs to be looked at perhaps a little more widely in the context of Clause 6.63, because on the face of it, Clause 6.3 says you're fixed or frozen as at the end of the transition period, and you decide the law according to what you think the European Court would have said then. Does Clause 6.2 allow you to override that, or is Clause 6.2 simply explicative? Is it there if to help you decide what the law was at the end of the transition period? Or if the European Court has clearly changed its jurisprudence, as it sometimes does, expanded it, changed the concepts a little, are you entitled under Clause 6.2 to use that despite Clause 6.3? The interrelationship of the two is simply not explained. It's not said to be, neither is said to be subject to the other.
Yeah. We have got quite a few people follow up. Baroness Coulson.
When you appeared before the committee a year ago, Lady Hale, you were asked about references to the Luxembourg court, and you referred to the fact that a reference could be made before Brexit, and then the answer would come back afterwards. And you actually said it would be good if we knew what the situation will be if the answer comes back afterwards, given that the litigation started while we were still a member. In discussions you've had with ministers or in looking at the bill, do you feel any clearer on this issue?
Well, we think we've got an answer that we will be bound by the answers that come back. And also, the thing that I was also very concerned about was questions arising out of facts that arose before Brexit, or indeed the end of the transition period, because it would be retrospectively changing the law if we weren't able to refer those questions and we weren't bound by the answers, which doesn't seem correct. But I think that's all now seems to be being sorted out.
Good. Lord Hunt.
I remember last time I was a little troubled when you and David Newberger said that you found sometimes the decisions of the Luxembourg court somewhat impenetrable. But we were reassured, although you said it was more difficult to engage with Luxembourg than Strasbourg, we were reassured when you said that you thought the visits by the CJEU coming to see us from time to time, and we visit Luxembourg, these visits will continue as we, no doubt, seek to resolve matters. What's the latest?
What's the latest? Well, we are hoping to have an exchange, a discussion with the members of the Luxembourg Court later this year on matters of substantive interest. Obviously, we can't engage with them on matters that are directly related to withdrawal, because that wouldn't be appropriate, but there are many areas of EU law which will continue to be of mutual interest, and we would like to be able to continue those friendly relations. I think the disconcerting thing was, on occasions, it is not always easy to interpret what they mean in their judgments. That's the problem. There have been occasions, and it is partly the result of the fact that their judgments are unanimous. And so they have to be the product of a great deal of negotiation to produce wording with which every member of the court who's sitting is comfortable. And that's a bit like a trade union negotiation in some respects. You know, people try and find a wording that suits, and then the poor national court that has to apply it sometimes finds it. That's what we were getting at in relation to the Luxembourg court. But it's not always the case.
Whereas if you have a majority verdict, the majority case is put in the minority one, is also explained,
Yes,
so that gives
right.
you extra clarity.
That's right, and they do allow dissent in Strasbourg, which is why it is easier to engage with the Strasbourg jurisprudence on occasions. I'm not saying this is a universal problem.
I think I was fascinated last time when it was explained that due to the unanimity required, often there would be some judges who were signing up to a judgment who fundamentally disagreed with it.
May I just add, I was in Luxembourg last week as a deputy for Lady Hale at the meeting of presidents of European Supreme Courts, and I think that continued relations, so long as we continue to look at retained EU law and so long as it's relevant to continue in any way to look at European court decisions, continued good relations will exist and are important. There's certainly no lack of friendliness on a personal level.
That's good.
Thank
Mechanic.
Yes, in relation, can I come back to the inadequacies of Clause 6.2? And can I ask you two questions? First, did I understand Baroness Hale to say that the court has not put to the government a revised wording that the court would be happy with? And could I suggest that might advance matters if the court were able to do that? And secondly, do you think that it would be better to have no provision rather than the provision currently in Clause 6.2?
Well, as to the first of those, we do not see it as our job to tell government what we would like to see specifically in wording in a piece of proposed legislation. We think that's inappropriate from separation of powers point of view. And the last thing we want is anybody to be telling Parliament, well, we've consulted the Supreme Court, and they say this wording is fine. And then, of course, we have a case and we find it's not fine. So that's not our job. What we can do is point out the problems with any existing draft. I think that is what has been happening. I think as far as the second question, I asked Lord Mance what he thinks about that.
I think the answer is that it would definitely not be a good idea to have no Clause 6.2, if only because it would then accentuate the importance of 6.3, which would stand by itself, and I don't think that's the intention, whatever the precise intention in 6.2 may be. So some guidance in the fallback position where there's no other regulation would be desirable.
And are you expecting the government to come back to you to put to the court its conclusion for further comments by the court before report stage?
It's not the court, it's this working group which Lord Mance is part of, and also another one of the justices and some Court of Appeal judges, with some Scottish representation as well. So it's not the court, no. But they are likely to come back with further drafts.
Yes. Lord Judge, you spent quite some time on this at the court.
Anything at all in the legislation, as opposed to taking out, for example, 6.2 and leaving 6.3? Do we actually need anything in the legislation? Judges know what they should be doing, don't they?
Well, I think that, I repeat, I think clause 6.3 would then become the dominant provision.
Yes.
But if you took that out as well?
If you took it all out, so there's no guidance, you simply carry on and make your decisions.
That might be a possibility, I have to say. Thank you.
Food for further thought. Lord Beath.
Could I just ask you about Section 1 of Schedule 1, which precludes judicial review as to whether any retained EU law was before exit day invalid. It's a curious provision because it's followed by a provision that the Minister can make regulations allowing such challenges. And it's not clear to me whether ministers do in fact intend to make such regulations, what they would be about, or when we would know whether there was going to be some possibility of legal challenge to the status of EU law as it existed before exit day. Have they consulted you about this at all, or told you anything about it?
I would have to ask Lord Mance whether they've...
We certainly noticed it, and we asked what the interrelationship was actually with clause 6.3, which does refer again to questions of the validity of any retained EU law. But I think the explanation was in relation to Schedule 1 that that clause really reflects the existing domestic position. Of course, it doesn't reflect the existing European position because you could challenge it before the court. So that it is, in that respect, on the face of it, a change.
Thanks.
Okay. In that case, shall we move on to judicial careers and diversity? Lord Judge.
On judicial appointments reflected concerns which I think are fairly broad about damaged morale within the judiciary and a reduction in the attractions of judicial office. Really what I think we would like to hear from you is what your views are on those subjects.
Well, we share everybody's concern that it has not proved possible to fill all the vacancies on the High Court for 2 competitions running now. It's a particular problem in Northern Ireland, where they have 10 judges and 3 vacancies. So that's almost a third of the court is missing. And that's obviously not sustainable for very much longer. The Lord Chief Justice is relying on the goodwill of retired justices. But it's equally going to be a problem with England and Wales. Scotland apparently doesn't have quite the same problem, but there are concerns about that too. The Judicial Appointments Commission has been very clear that it's not going to drop the quality, it's not going to lower the standards in order to fill the vacancies. So, of course, we have to be concerned about it. It's not going to affect the Supreme Court for some considerable time, but one of these days it might do. But we're concerned for the system as a whole. And of course we share the general diagnoses that are around, that were in your report, for which many thanks, incidentally. It's a very helpful report. That pay is one thing, but not as important as the change to the pension scheme. And part of the problem with the change to the pension scheme is that it not only affected new recruits, which is one thing, it was that it changed the pension arrangements for a large number of people who had become judges, accepted appointment on the basis of the previous pension scheme. And that undermined trust and confidence, shall we say, and undermined morale. And if things can be changed after you've given up a lucrative career for public service, that's not much of an incentive. So that's a concern that we have, and we've actually expressed that concern in evidence to the Senior Salaries Review body, which is reviewing judicial salaries at the moment. There are other things people do, but they're in your report. You know all about them. You probably know more about them than we do, because we live in our ivory tower across the road.
Well, so far the ivory tower's been penetrated. So effectively, I think what you're saying, and it's very clear, is that we've just about got this right in our report, from your point of view. And Lord Mance?
Yes, I mean, I've read the material which is being put before the SSRB, not just from us, and there's some very, very powerful statistical evidence which confirms one's own anecdotal view that morale is low and people are retiring early. We're not getting recruits. There's been a cultural change, unfortunately, as a result of the combination of factors. It's no longer the ultimate ambition of many members of the bar, is my impression, and I think that's going to be deleterious and perhaps difficult to reverse, but there's no doubt it's occurred.
Yes, thank you. Thank you.
Barrett, when you said the situation is not quite as bad in Scotland, is that because they're doing something else, or there's a factor there, or it's just one of those things that happens from time to time, that there's different approaches?
They seem to be managing to fill the vacancies.
Is there anything they're doing that we should learn from?
I don't know the answer to that. If I were to speculate, it would be pure speculation, and I wouldn't want to. I just know that is the figures are like that.
Well, Panic?
Can I just ask me how significant a factor is abuse of the judiciary? And I don't mean criticism, I mean abuse, enemies of the people type abuse, and how significant is the general perception of a lack of support from the Ministry of Justice in relation to such matters?
I almost want to say to Lord Panic, he's likely to know the answer to both of those questions better than we do. We are serving judges. We are not being deterred because we are serving judges, whereas Lord Panic, as a practicing barrister, is in contact with many people from whom he can ask that information.
Very good. I thought I'd ask.
But it certainly was a significant step when that level of criticism was raised in the way that it was.
But, yes, and of course we were all very concerned about that. But that concern was sufficiently voiced, I think, to have got home. And things do seem to be very different, to have been very different.
But not voiced quickly by all ministers.
We found that the reaction to the Supreme Court decision in the Miller case was perfectly acceptable.
I think we'll move on. Lord Beith.
You're recruiting now, I think, for new Deputy President and 2 or possibly 3 Supreme Court judges. Are there any particular steps that you're taking to try to attract a diverse range of candidates for these posts?
Well, we have done this time round what we did last time, which was advertise the posts widely, draw the attention of a range of bodies to the existence of the posts, offer outreach visits to the court. I have not myself been involved in those activities because I'm chairing the commission that makes the appointments. And so I can't tell you how many people took it up, and of course I can't give you any figures about applications and diversity of candidates, because that would not be appropriate at this stage.
Has Lord Mance noticed whether visitors are on the premises for the kind of recruitment process described?
Yes, but I don't think I should say more.
Right. And of course, there's been the recent appointment of Lady Black to the court. What steps are being taken to ensure that more women applicants consider taking up posts in the higher echelons of the judiciary, including the Supreme Court itself?
Well, there are a number of initiatives, and again, you mentioned them in your report about judicial recruitment, aimed at making people feel that they can put themselves forward and that it will be welcome if they do put themselves forward. And there is Lady Justice Hallett's group, which offers support and mentoring to people, all sorts of diverse candidates who might not otherwise think of putting themselves forward. I think the real problem, which you slightly hint at in your report, is that this doesn't apply so much to women who come from conventional legal backgrounds, but there are, of course, a lot of able people who come from different career paths who could make excellent judges. But the difficulty that I think the appointing commission have is in how do we assess merit and potential in people who haven't come through the traditional career path.
You didn't come through the traditional career path in that sense.
Yes, I don't know how they took the risk.
You seem to have particular problems in this country, Lady Hale, as you point out in one of your lectures, compared, for example, with France, where Lord Jug has recently been speaking. I mean, there the judiciary is almost being feminized, it said, and in addition, of course, as you well know, they have a quite separate way of judges emerging. It's a separate career structure. Do you think those two things are related?
Undoubtedly. And it's not only France. It's also the case in Italy and in Spain and Germany. They have a large number of women judges, though they do tend to be concentrated in the lower ranks, which of course is also the case here. But the explanation tends to be that they have a judicial career. You do your law degree and then you decide whether you're going to be a practitioner, an academic or a judge. And if you want to be a judge, you go and do the judging exams. And at that stage, you know, these young women law graduates are rather good at the judging exams. And so they get in. Whether they then get promoted to the more senior positions, that is often a difficulty that they face as much as we do, because, for a start, they may have to be mobile, and mobility is always a problem in dual career families, and most professional women are partnered with professional men, and mobility is a problem for both of them. So I think that's a large part of the explanation for that. And it's not a path down which we really think we should be going, because we like the fact that our judiciary have done something else with their lives before they became judges.
Another factor is, of course, that our oral tradition, the fact that we spend a lot of time in court, makes it more difficult, I think, for some women. One of the attractions of a judicial post in Germany, for example, is that you can do a lot of work at home. It's easier to fit with your family life.
But that applies to other professions in this country, doesn't it? I think of a large number of professions where women are likely to be, at work for long hours, and nevertheless they do seem to emerge. Why is the judiciary slower than others?
Well, I think the judiciary has, at lower levels, done much better in recent years. But
Good.
And Lady Hale came up through the ranks, if one can put it like that. I don't want to subscribe to the view too forcefully of trickle up, but we have made slight progress recently, and I'm sure we'll make further progress.
Yes, we have. Actually, there has been very considerable progress. I think the figures are now something like 48% of the tribunal judiciary, it's really quite high. 38% of the district bench, I think roughly a quarter of the circuit bench, under a quarter of the High Court bench, but a quarter of the Court of Appeal, but no heads of division. And of course we did double the number of women in the Supreme Court from 1 to 2 last year.
Baroness Corson, would you like to follow that?
Well, yes. Given your own background, Lady Hale, are you telling us that particular efforts are made to contact and encourage women who are currently academic lawyers?
Well, certainly attempts have been made. They were made last year, as I say. I've tried to step back from those active outreach attempts because I'm currently engaged in the selection process.
Yes, of course.
And so we have to keep that under wraps. But yes, we're back to the question, how do you compare the merits of somebody who is currently an academic lawyer who also fulfills the professional qualification that's required against somebody who's currently in the Court of Appeal? It's not an easy thing to do.
But should there always be a presumption that somebody who's got that other experience is going to be more appropriate as an appointment?
Well, I wouldn't say that. I would say that in a collegiate court, which is wholly engaged in points of law of general public importance, a range of professional and other backgrounds is a positive benefit. That's what I would say, but others may take the view that substantial judicial experience is rather important in judging at the highest level.
Baroness Drake, did you want to expand on that a little?
Yes, just taking that last point and then coming back to another question. I mean, some of that struggling with how to assess relative merits between candidates does flow from this assumption of what a good candidate looks like, or what the qualifications of a good candidate looks like. How do you think you're going to overcome those misconceptions? Because they're kind of deep-rooted, aren't they? How does one begin to change views and attitudes?
Well, you probably begin to make a few appointments and make a few appointments of people from different career paths and different backgrounds. There have been some recent appointments to the High Court bench from the upper tribunal, for example. That has improved the number of solicitors who've become High Court judges, and also people from government legal service, or indeed from the parliamentary clerks. There's a High Court judge who was a parliamentary clerk. So the more of that we have, the more it can encourage people that it's all right, it can work. So I think example is the best thing.
Role models and breakthroughs.
Yeah.
But in terms of having a judiciary which is more reflective of the population that it serves, which is something you yourself, Lady, have commented on recently, women are one dimension of that diverse population. It is obviously other characteristics and other people. What assessment would you make of the steps that are being taken to deliver or to attract non-traditional candidates to apply for these posts across that greater, more diverse world?
Well, I haven't looked into, in an intense way, what the Judicial Appointments Commission is doing, but I know they are doing things to attract other candidates. What I find concerning is they're getting a lot more diverse candidates, but the success rate of those more diverse candidates in being appointed is less than the more traditional candidates. That doesn't really apply to the women, but it's more to people with different backgrounds. And that goes back to what I was saying earlier. Is that because they're not so good, they're being encouraged to apply, but they're not actually good enough? Or is it because the assessment processes are not good at capturing the real talent that is there, but it's harder to assess? It's probably a bit of both, isn't it?
Thank you.
And to what extent are those who are not successful given advice or a steer on what they need to do should they need to come back?
Well, certainly we in the Supreme Court selection process, we do offer feedback. Feedback is, as I understand it, offered by the Judicial Appointments Commission, but quite in what form and quite how useful it is, I couldn't possibly comment because I don't know.
Lord Mans, is there anything you want to add on this topic?
No, I don't think there is.
Okay. In that case, let us move on to devolution. Lord Morgan, would you like to start?
Well, I've been asking about this in the recorded memory of man, I think, and I'd be very interested now because the Welsh Assembly is producing more and more legislation with the new powers that it has, so the corpus of Welsh law is quite considerable. There is, of course, a Scottish judge on the Supreme Court, latterly Lord Hope it was. Do you think it would be appropriate to have a Supreme Court justice who had a specific knowledge of Welsh law, please?
We are aware, of course, that the Welsh Assembly is legislating with great enthusiasm. And so there is a developing body of Welsh law. And in some respects, we are, at least those of us who have been members of the Law Commission, are very pleased that the Welsh Assembly has legislated for Law Commission proposals, which the UK Parliament hasn't done for England. So we look with interest at what is going on in Wales. There isn't, as far as I know, yet much case law interpreting the Welsh legislation. It is, of course, all legislation, Welsh law. There isn't a Welsh common law. So, but we are very fortunate in the Supreme Court that amongst the 3 recent appointments, there is a Welshman.
Yes, yes.
And sufficiently Welsh to have taken his oath in both Welsh and English.
Yes, I noticed that. Yes.
And he is thoroughly familiar with the developments that are going on in Wales. And so if and when cases come up to the court on the interpretation of Welsh legislation, I am sure that he will be sitting on the panel that deals with them, and his views will be very influential. Because sometimes it's not, we can all interpret legislation. That's one of our supposed skills. So there is a view that says, well, it's Welsh legislation, that's all right, it's legislation, we can interpret it. But sometimes knowledge of the context and purpose is important in interpretation. And this is where having a Welsh justice will be particularly beneficial. But that wasn't because of any sort of quota of having to have a Welsh justice. It just happened that he was the best man for the job.
Yes, it so happened that, do you think it's a precedent that ought to become the norm, perhaps?
Well, possibly we'll see what the experience is, how many cases we get, and whether in fact they're the sort of case where that perspective would be useful. We can, of course, always ask a member of the Court of Appeal to join us if we don't have a Welsh justice. And we did that when Lord Thomas was Lord Chief Justice, because he too is a real Welshman. And so whenever we did have a Welsh case, I think whenever we asked him to join us. I remember being in a minority with him in one case involving the well, actually, whether it was within the powers of the Welsh Assembly to pass a particular piece of legislation. But we can always do that.
Yes, thank you.
One problem about having a quota is we've always have 2 Scots.
Yes,
and that is because Scottish private law is in several respects different from English private law. And so if you have 2 Scots and they both think it the same, the English are unlikely to disagree with them. If, of course, they disagree with one another, the English will feel freer to choose between them. But we have 2 Scots. And we also have a judge from Northern Ireland. So if we then had a judge from Wales, that would be a third of the court that had a sort of ethnic quota. And one has to just be a little bit concerned about what the implications of that would be for the other dimensions of diversity.
Yes. If the calls for a Welsh jurisprudence were accepted, would that make the case stronger for having a Welsh member of the Supreme Court as a permanent feature?
I think it depends on the future developments and the volume of the work. If there were a significant volume of Welsh work, as there is from Scotland, Scottish work, then clearly the case would be stronger. But I do actually share Lady Hale's view about quotas. I think one could fill up the court with quotas, which wouldn't in any way reflect the balance of work which we undertake, or indeed reflect other divisions which one could make within society. So I would be, at the moment, I think the present situation is a suitable balance.
Yes, thank you very much.
Lord Dunlop.
I could ask you a general question about devolution, Lady Hale, and to ask you about the Sewell Convention, which obviously arose in the Miller case, and I think you spoke about it in your Cambridge lecture last July, and obviously drew attention to the fact that Sewell is a political, not a legal commitment, and is therefore not justiciable. And I think you highlighted the importance of that very simple word, normal. And what I wanted to ask was, if you remove the word normal in statute, does that then become a justiciable matter? And if it does, how significant a constitutional change do you think that would be?
Oh dear, that's a very difficult question, because it's the sort of question that might come up before us were that ever to happen. And then we would obviously have to look at the arguments and see whether, in fact, that word had made all the difference to the view that we took, the unanimous view that we took of the current provisions enshrining that convention in statute. It's obvious what a problem that a word like normally, because how is a court to judge what is normal and what is not normal in what by definition is a pretty abnormal situation? So it isn't, it's a bit like appropriate, you know, not a good word. But there might be other arguments to say that in any event that was simply putting on the statute book something which is a parliamentary convention rather than a binding rule of law. And we would have to look at the arguments again in that situation.
Okay.
Before we go off that point, I think that Lord Norton was risking at the word convention.
Digress, because I mean you made the point that the insertion of the word normal means it's non-justiciable, but the insertion of the word normal means it's not a convention. Because a convention is an invariable practice, and this is giving the option to depart from it. So there's even a problem with it as a convention. It is a practice, and that's different.
Well, you're the expert.
That's why I let him say this at this time. I thought it was appropriate. Let's move on and not play with words.
News that the Supreme Court is going to sit in Belfast in April, and I think that will help to raise the profile and promote the understanding of what the Supreme Court does outside London. And I wondered whether this was going to become an established feature of the Supreme Court, and you would sit elsewhere in the UK. And perhaps you could say a little bit about your commitment more generally to making the court more open and accessible.
Well, as far as sitting outside London, yes, we went to Scotland last year, and that seemed to be very well received. We're going to Belfast soon, and all the indications are that that too will be well received, at least while we're there. It may depend upon the results of the cases as to whether it's quite as well received once we've done it. And I'm tolerably confident that we will go to Wales next year. It would be wonderful if we could go to the north of England,
exactly,
to the southwest, the places which are far-flung, but this may not be practicable. We have to take a lot of people and a lot of gear with us, because, leading on to your second point, we do, of course, broadcast our proceedings. Anybody could watch. Anybody who's got access to a computer can watch our hearings. So we're already much more open and transparent than the other courts in the United Kingdom. And it's amazing how many people do.
Well, I was going to ask.
Well, I haven't got the figures with me. I should have brought them with me. But a lot of people watched all 4 days of the Miller case. Now, I know that's partly because Lord Panic's starring role, but it was quite surprising, and I think that was part of getting the knowledge of what we were doing over to the general public. So we do that. That's the most important thing that we do. But we also have a lot of visits, outreach to schools. We're piloting shortly Skype a Justice, so that schools a long way out of London who will find it difficult to visit the court can dial up and have half an hour session asking questions of a justice. It's an experiment, and we're only about to try it, but it sounds like a good idea to us. We welcome visitors of all kinds. People can just walk in off the square. It's rather easier to get into our building than it is to get into this one, so we do find that we have more casual visitors, which we like. And we're doing as much as we possibly can to encourage people to find out about us, to reach out to people. And we all go out and about a lot anyway, talking to different groups and so on. We go to universities quite a lot, but we also go to other types of group. And probably give far too many lectures.
But when you say the possibility of going to the north of England is somewhat difficult, I mean, if you actually were to go about in the country a little more, particularly to the north of England, that might actually help with recruitment throughout and changing the actual imagery of a London-based, very sort of specific type of person who makes progress in the judiciary.
Yeah. Well, of course, I would agree with you, wouldn't I? Being a Yorkshire woman myself, and indeed, the second woman is also a Yorkshire woman. So we've increased the northern representation on the court as well. But yes, it would be wonderful if we could manage to do that. But as I say, there are logistical problems. It takes a lot of planning. It obviously is not inexpensive, and so we can only do it as much as we can do it.
Yeah. Yes. Okay, Lord Norton, do you want to?
Yes. You mentioned location, and of course, the Supreme Court will soon be coming up to its 10th birthday. Now, you both served as law lords, so you know the difference of having the highest court within Westminster and then moving across. It affects not just physical, but there is the relationship then of the court to Parliament. And I wonder how you saw that developing, not least in terms of accountability. It's something we raised in a previous session, you may recall, about that relationship. Are you developing what Alison Young referred to as a democratic dialogue? And if so, how can the relationship be strengthened while at the same time, of course, maintaining the independence of the court?
Well, occasions like this are a very important part of that, and we welcome the opportunity that we have to come and answer your questions to the best of our ability. And we hope that enables you to understand our perspective, just as we understand yours. We've not so frequently engaged with the Justice Committee in the House of Commons, but we would be very open to doing that. We can't, of course, discuss individual decisions because they speak for themselves, and it would be inappropriate for you to be challenging us about the decisions, just as it would be inappropriate for us to be seeking to defend them. It's just not right. So we are conscious that we are accountable generally,
yes,
we have to explain our decisions. We have to explain them as clearly as we possibly can, and we have to make it clear that we have reached those decisions by a process of judicial reasoning, which is not just plucking it out of the air and doing what we fancy. It is actually starting with the legal materials that we have, going on to the legal principles that can be deduced from those legal materials, and then asking, well, how does that fit with the situation that we have? And that sometimes involves incremental developments of the law to fit new situations as they come up and new social circumstances as they come up. But it doesn't involve a revolution. So I think our judgments are our main focus of accountability. But it is difficult, isn't it? Because we're no longer in Parliament. That's, to my mind, I'm afraid, a good thing. Much though I enjoyed being here, I'd say so. But we are doing a different job, and we should be seen to be doing a different job. And we can do things with the transparency and so on, which we couldn't do here. So we are in many ways more transparent now than we were when we were in this room. So that's a good thing. But unfortunately, it would be wonderful if parliamentarians did acquaint themselves rather more thoroughly with what we do.
Yes, that's what I was thinking. As you say, moving across the area, we've had to focus on thinking about then the relationship with Parliament and whether there's more we could do other than regular hearings, which we find very useful because we also hear from the Lord Chief Justice and there are opportunities to raise broad issues, to do so with the administration or the recruitment. Whether you think there's anything that should complement meetings such as this.
We would, of course, always be happy to welcome parties of parliamentarians over the square, show people around, observe a bit of a hearing, have a bit of a dialogue with justices. We would be very happy for that. So, in a way, the ball's in your court.
And do you think there's anything more you could do if you wanted to raise an issue with us rather than wait until, say, we had a regular meeting?
Well, I'm fairly sure we could do that. Yeah. I'm struggling to think what the issue would be, but there might be something. We also do meet the parliamentary clerks in an informal way, just so that, again, we can toss about things that might crop up, because they're the great guardians of parliamentary privilege, which we're very conscious of.
Indeed. Thanks.
Well, maybe we could draw your comment about parliamentarians going across there to the to speakers of both houses, and they might then be able to consider how they might be able to promote that a little more in the future, and that might.
In my time on the Justice Committee, the Supreme Court justices were very helpful in coming before the committee and developing a discussion which was a kind which was appropriate to their position, using that awful word appropriate, and in facilitating visits across to your premises.
Yes.
I think the difficulty is that you come and give evidence to people who are interested, and people who are interested ask you questions, but those who don't know as much about it don't participate, so they don't get within the loop. And I think that's where perhaps we need to make the effort to widen that level of the interest amongst other people.
Yes, that would be welcome. Thank you.
Is there anything else, Lord Baroness Hale, that you would like to focus on in terms of it? In that case, may I thank you. And Lord Baroness, I understand you're retiring shortly. So
that's right. Yes, I'm one of the those who are fortunate enough, perhaps, to be able to come back here.
Well, we wish you well in your retirement, however, whatever form that may take.
I feel fairly sure that Lord Mance will be back amongst you, playing an active part.
Get ready for long hours.
Indeed. Thank you both very much.
Thank you very much. Thank you.
The proceeding has ended. 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 The proceeding has ended.